Imagine walking through the beer aisle at your local grocery store. You see Budweiser, Coors, Miller Lite. Pretty standard stuff, right? But then, your eyes land on something different. A green cartoon frog flipping you off. Yes, you heard that right. This isn't a prank or a gag from The Simpsons. It's a real beer brand, Bad Frog Brewery. And that little frog didn't just cause a stir at the liquor store, it kicked off a legal battle that made judges ask, does the Constitution protect a frog giving the middle finger? Back in the mid-90s, craft beer was just starting to bubble up. Small breweries had to grab attention somehow. Some went for bold flavors, others for cool designs. Bad Frog? They went for shock value. Their pitch was simple. We're not your dad's beer, we're edgy, we're bold, and our mascot doesn't care about your rules. So they designed that infamous label, a grinning frog proudly holding up that finger. But here's the catch. In New York, beer labels need approval from the state liquor authority first. Bad Frog sent theirs in, probably expecting a chuckle and a stamp of approval. Instead, they got a big fat no. Officials argued it was too vulgar, especially since kids could see it. Picture this. A parent pushing a cart and little Timmy asks, "Mom, what's that frog doing with its hand?" Yeah, not the conversation you want on a Saturday. But for Bad Frog, this wasn't just about protecting kids, it was about censorship. They said, hey, this is free speech. We have the right to put our rude little frog on a bottle. And they sued. Now you might think, really? A lawsuit over a cartoon frog? But this was bigger than it looked. The First Amendment protects free speech, and yes, that includes product labels. But commercial speech is more vulnerable. So, the real question was New York's reason, protecting children from a frog flipping the bird, good enough? The case made its way to the U.S. Court of Appeals, where actual judges debated the fate of a cartoon amphibian. Imagine the law clerks writing memos with a straight face. Your Honor, the central issue here is the frog. The state doubled down, claiming they were protecting kids, but the judges weren't buying it. One judge pointed out that kids are already exposed to worse, violent TV shows, rap lyrics, playground language, shielding them from a cartoon frog? That wasn't preserving innocence. And here's the kicker. The state had other options. They could have restricted where the beer was advertised or banned displays near schools, but they chose a total ban on the label. The judges called that overkill. So, what was the final ruling? The frog won. The court decided Bad Frog Brewery had the constitutional right to put its rude little mascot on beer bottles. Offensive? Sure. Immature? Definitely. But protected speech under the First Amendment? Absolutely. Now you might ask, why does this matter today? Because it shows that free speech protections aren't just for grand debates. They cover the weird, the silly, and even the crude. If the government can ban a frog for being offensive, what's next? A sarcastic slogan? A meme? This case became a law school classic, reminding everyone that the First Amendment protects more than what's polite or popular. Sometimes, it's there to protect a frog with an attitude problem. So next time you're in the beer aisle and see a wild label, remember, somewhere in American law, a cartoon frog raised its middle finger and won. Because free speech, believe it or not, even covers the amphibious. Thanks for watching. Don't forget to like, subscribe, and comment below with your thoughts on this wild legal battle.